What to do if your visa to Ukraine is rejected? My name is Ivan Goncharov. I'm an immigration lawyer. First of all, let's talk about most common reasons for visa rejection to Ukraine. According to the law of Ukraine, there are 11 reasons for visa rejection. If you will look at the visa rejection letter, there is a point number 8, failure to prove the purpose of intended stay in the territory of Ukraine. This is the most common reason for visa rejections to Ukraine. How we can understand this reason? It means that either the diplomatic mission of Ukraine, the embassy or the consulate, or the competent authorities of Ukraine came to the opinion that they don't trust the applicant's real purpose of coming to Ukraine. It's worth noting that the only decision maker is the embassy or the consulate of Ukraine. However, as I've mentioned, there are competent authorities in Ukraine who, in certain situations, can recommend to abstain from issuing the visa to Ukraine, and the embassy or the consulate never go against such recommendation. The first competent authority is the State Security Service of Ukraine. It also can be the National Police of Ukraine, Migration Service, or Border Guard Service. Usually such a visa refusal decision because of the failure to prove the purpose of visit to Ukraine can receive citizens from certain countries, so-called list of high risk of illegal migration countries. According to the law of Ukraine, there are 70 countries in this list. For applicants from those countries, the diplomatic mission of Ukraine has to be more attentive. They can invite the person for their personal interview to talk about the purpose of visit to Ukraine. They also can demand extra documents as well as to contact the inviting party in Ukraine. The same can do the Security Service of Ukraine. They can contact the inviting party to clarify whether they do know the applicant. As for other reasons for visa refusal decision, it can be absence of documents which prove that the person has documents which prove that he will leave the territory of Ukraine on time. Or the applicant can fail to provide documents which prove that he has sufficient financial means. Or absence or invalid medical insurance. The other reasons include providing false information or forged documents. And the most difficult and rare cases, a visa can be refused to Ukraine in case of a potential threat to the national security and public order, or an existing entry ban to the territory of Ukraine. Once the applicant will receive the visa refusal letter, he will have 60 working days to consider either to appeal such a refusal or to reapply for a new visa. As for the appeal, the applicant can submit an appeal letter to the same diplomatic mission which refused the visa. It's worth noting that the right for the appeal is free of charge. There is no need to pay again the visa fee. How much time does it take for the appeal? Usually it takes the same time as the applicant waited for the initial visa. It can be about from 10 to 20 working days, however not more than 30 days. Why needing an immigration lawyer to appeal visa refusal decision to Ukraine? Apart from the professional legal consultations based on the comprehensive assessment of the case circumstances and documents, a lawyer can draft a strong appeal letter which will maximize the chances for the visa success. A lawyer can also represent interest of the applicant with competent authorities in Ukraine by sending requests to them for collecting extra information and documents copies. A lawyer can also draft extra support letters for the applicant to maximize his visa chances. If the appeal letter was rejected, the applicant can appeal to the court in Ukraine. However, the applicant can also apply for a visa again. Trust your cases only to professional lawyers who have expertise in certain matters. Thank you for your attention.